Hello everyone, I'm Leonard French, your favorite copyright attorney, and today I'm presenting our analysis of a patent case thanks to the sponsored request of Patreon supporter DJ Gilcrease. Thank you very much for your support, DJ. This past summer, a long-fought legal battle between Lexmark and Impression Products finally ended on May 30th, 2017, when the Supreme Court ruled against Lexmark's patent claim against Impression Products. Lexmark, as you may know, makes office supplies including printers and toner. Impression Products is an ink and toner cartridge remanufacturer, meaning they refill old cartridges and sell them at a discount. Lexmark tried to claim that Impression Products was infringing on their patent by reselling the refilled cartridges. The Supreme Court disagreed. Now, why would Lexmark spend years and potentially millions of dollars to fight printer cartridge remanufacturers? To understand, we need some background. But before we get started, I wanted to take a moment of silence for the Puppy Justice Automated YouTube channel, who reported on this very same Lexmark case last May. The channel was pretty much what you see here, dogs and farm animals dressed as participants in a courtroom scene. And it's a pretty freaking awesome way to listen to the oral arguments in this case. I suggest you check it out after you watch the entirety of this video. It was also the very last video that Puppy Justice Automated put out. Moving on. Ink and toner cartridge pricing explained. Printers are usually sold with little to no profit to encourage customers to commit to the brand. Manufacturers like Lexmark mark up printer ink and toner and rely on the customer continually buying replacement cartridges to keep up the flow of profits. This is known as the razor and blade pricing model and was popularized by Gillette, who would sell their razors at a loss but sell the blade replacements at a higher profit margin. It's also called a leader loss model, and we see it in gaming consoles to encourage buying games, in Keurig coffee machines and K-cups, in laptops and peripherals, and the list goes on. Companies are doing this everywhere. Another complication to this business model is that although toner itself is cheap, the cartridges are complex. Like many companies, Lexmark has invested in their cartridge technology. To protect their investment and business model, they have several features, including microchips, to make sure that only Lexmark cartridges will work in their printers and that a cartridge can only be used once. They have dozens of patents on their ink and toner cartridge components and copyrights to the digital programming that restricts reuse. Lexmark claims that third-party cartridges may cause poor performance, jams, and messes. They've put out this video urging customers to use genuine Lexmark products to maximize performance and stay in warranty. However, there are companies, such as Impression Products, that will buy and refill old cartridges, bypass the technological lockouts, and sell the refurbished product. Since the toner is cheap compared to manufacturing the cartridge, and Impression Products isn't trying to make up for the loss leader pricing of a printer, they can sell at a discount. We all know that ink and toner can get pricey, so how much of a discount do resellers give? Let's check out some prices from Lexmark on Amazon. On American Amazon, a genuine cartridge is about $65.61, and a remanufactured one is around $57, a savings of about 13%. The deal. To combat this, Lexmark came up with a loyalty pricing program. Customers could buy regular toner cartridges, no strings attached, or they could promise, via an agreement, otherwise known as a contract, to return the cartridge to Lexmark for approximately 20% off. However, this hasn't stopped remanufacturers from obtaining empty Lexmark return program cartridges both within the US and from other countries. Lexmark v. Impression Products. When Impression Products remanufacturing cut into Lexmark's profits and threatened their business model, Lexmark sued them for patent infringement. In 2010, it sued with respect to two groups of cartridges. One group consists of return program cartridges that Lexmark sold within the United States. Lexmark argued that, because it expressly prohibited reuse and resale of these cartridges, the remanufacturers infringed the Lexmark patents when they refurbished and resold them. The other group consists of all toner cartridges that Lexmark sold abroad and that remanufacturers imported into the US. Lexmark claimed that it never gave anyone authority to import those cartridges, so the remanufacturers ran afoul of its patent rights by doing just that. So what exactly is a patent, and what rights does it give? A United States patent entitles the patent holder, the patentee, for a period of 20 years, to exclude others from making, using, offering for sale, or selling its invention throughout the United States or importing the invention into the United States. Whoever engages in one of these acts without authority from the patentee may face liability for patent infringement. These enumerated rights, making, using, offering for sale, selling domestically or internationally, these are part of what is called the bundle of rights. Each right is analogized to a stick in the bundle. This sometimes burdensome bundle of sticks is often used to describe what a property owner, including a copyright or patent holder, owns. They own each of the separate rights in the bundle and don't necessarily lose the other rights when they give or assign one away. At first, it may look like Lexmark has patents on their cartridges that can stop impression products from using, offering for sale, or selling its invention or importing it into the United States, but the case is a little more complicated. We've seen in Disney v. Redbox and Redbox v. Disney that there is a right of first sale in copyright, meaning that once you sell a copy of your work, you can't stop someone from reselling that one copy. But what about patents? Is selling a used car an infringement of the manufacturer's patents? What about buying a used phone, laptop, or camera? Usually no. From the court, when a patentee sells one of its products, however, the patentee can no longer control that item through the patent laws. Its patent rights are said to exhaust. The purchaser and all subsequent owners are free to use or resell the product just like any other item of personal property without fear of an infringement lawsuit. But Lexmark argues that because they put reselling restrictions on their return program cartridges, they explicitly retain some of their patent rights. There was no lawful way for impression products to get the returned cartridges, and therefore they aren't allowed to sell them. From the court. This case presents two questions about the scope of the patent exhaustion doctrine. First, whether a patentee that sells an item under an express restriction on the purchaser's right to reuse or resell the product may enforce that restriction through a patent infringement lawsuit. And second, whether a patentee exhausts its patent rights by selling its product outside the United States where American patent laws do not apply. We conclude that a patentee's decision to sell a product exhausts all of its patent rights in that item, regardless of any restrictions the patentee purports to impose or the location of the sale. So how did the Supreme Court come to this decision? The lower court, the district court, dismissed Lexmark's claims for domestic sales since Lexmark had exhausted its patent rights. But the court denied a motion to dismiss regarding the cartridges purchased abroad and imported into the U.S. Both Lexmark and Impression Products appealed the district court's ruling. In a 90-page decision, the Federal Appeals Court ruled that Lexmark had not exhausted its patent rights domestically or internationally because it had clearly communicated to the customer that it had retained some rights and the return program contract was otherwise valid. This is how the Supreme Court, though, described the federal court's decision. The federal court considered the appeals en banc and ruled for Lexmark with respect to both groups of cartridges. The court began with the return program cartridges that Lexmark sold in the United States. Relying on its decision in Mallinckrodt v. Metapart, the Federal Circuit held that a patentee may sell an item and retain the right to enforce through patent infringement lawsuits clearly communicated lawful restrictions as to post-sale use or resale. The exhaustion doctrine, the court reasoned, derives from the prohibition on making, using, or selling or importing items without authority. When you purchase an item, you presumptively also acquire the authority to use or resell the item freely, but that is just a presumption. The same authority does not run with the item when the seller restricts post-sale use or resale. Because the parties agreed that impression products knew about Lexmark's restrictions and that those restrictions did not violate any laws, the Federal Circuit concluded that Lexmark's sale had not exhausted all of its patent rights, and that the company could sue for patent infringement when impression products refurbished and resold return program cartridges. As for the cartridges that Lexmark sold abroad, the Federal Circuit once again looked to its precedent. In Jazz Photo Corp v. International Trade Commission, the court held that a patentee's decision to sell a product abroad did not terminate its ability to bring an infringement suit against a buyer that imported the article and sold it in the United States. That rule, the court concluded, made good sense. Exhaustion is justified when a patentee receives the reward available from selling in American markets, which does not occur when the patentee sells overseas, where the American patent offers no protection and therefore cannot bolster the price of the patentee's goods. As a result, Lexmark was free to exercise its patent rights to sue impression products for bringing the foreign-sold cartridges to market in the United States. Judge Dick, joined by Judge Hughes, dissented. In their view, selling the return program cartridges in the United States exhausted Lexmark's patent rights in those items because any authorized sale of a patented article frees the article from any restrictions on use or sale based on the patent laws. As for the foreign cartridges, the dissenters would have held that a sale abroad also results in exhaustion unless the seller explicitly reserves its United States patent rights at the time of sale. Because Lexmark failed to make such express reservation, its foreign sales exhausted its patent rights. So, the Supreme Court granted certiorari and agreed to hear the case. Here is their reasoning for reversing both decisions of the federal court. First up are the return program cartridges that Lexmark sold in the United States. We conclude that Lexmark exhausted its patent rights in these cartridges the moment it sold them. The single-use, no-resale restrictions in Lexmark's contracts with customers may have been clear and enforceable under contract law, but they do not entitle Lexmark to retain patent rights in an item that it has elected to sell. The Patent Act grants patentees the right to exclude others from making, using, offering for sale, or selling their inventions. For over 160 years, the doctrine of patent exhaustion has imposed a limit on that right to exclude. The limit functions automatically. When a patentee chooses to sell an item, that product is no longer within the limits of the monopoly and instead becomes the private individual property of the purchaser, along with the rights and benefits that come with ownership. A patentee is free to set the price and negotiate contracts with purchasers, but may not, by virtue of his patent, control the use or disposition of the product after ownership passes to another purchaser. The sale terminates all patent rights in that item. This well-established exhaustion rule marks the point where patent rights yield to the common law principle against restraints on alienation. The Patent Act promotes the progress of science and the useful arts by granting to inventors a limited monopoly that allows them to secure the financial rewards for their invention. But once a patentee sells an item, it has enjoyed all the rights secured by that limited monopoly. Because the purpose of the patent law is fulfilled, when the patentee has received his reward for the use of his invention, that law furnishes no basis for restraining the use and enjoyment of the thing sold. We have explained in the context of copyright law that exhaustion has an impeccable historic pedigree, tracing its lineage back to the common law's refusal to permit restraints on the alienation of chattels. Chattel is just personal property besides real estate, so my computer, my microphone, my car are all chattels. So then, alienation of property means that you can make it no longer yours, meaning you can dispose of, sell, or transfer that thing. When something is inalienable, it means you can't lose it or sell it, so certain rights are sometimes called inalienable. Alienation of goods is important for a free market. You need to be able to buy, sell, and transfer money and goods. It's what lets us have capitalism. This venerable principle is not, as the Federal Circuit dismissively views it, merely one common law jurisdiction's general judicial policy at one time toward anti-alienation restrictions. Congress enacted and has repeatedly revised the Patent Act against the backdrop of the hostility towards restraints on alienation. That enmity is reflected in the Exhaustion Doctrine. The patent laws do not include the right to restrain further alienation after the initial sale. Such conditions have been hateful to the law from Lord Coke's day to ours, and are obnoxious to the public interest. The inconvenience and annoyance to the public that an opposite conclusion would occasion are too obvious to require illustration. But an illustration never hurts. Take a shop that restores and sells used cars. The business works because the shop can rest assured that, so long as those bringing in the cars own them, the shop is free to repair and resell those vehicles. That smooth flow of commerce would sputter if companies that make the thousands of parts that go into a vehicle could keep their patent rights after the first sale. Those companies might, for instance, restrict resale rights and sue the shop owner for patent infringement. And even if they refrained from imposing such restrictions, the very threat of patent liability would force the shop to invest in efforts to protect itself from hidden lawsuits. Either way, extending the patent rights beyond the first sale would clog the channels of commerce, with little benefit from the extra control that the patentees retain. And advances in technology, along with increasingly complex supply chains, magnify the problem. A generic smartphone assembled from various high-tech components could practice an estimated 250,000 patents. So the court is arguing a few things. First, that Congress has revised the Patent Act keeping in mind the patent exhaustion doctrine, and in general, Congress isn't in favor of things that interfere with the free market. Also, it's in the public's best interest to have a strong patent exhaustion doctrine to help protect downstream buyers and sellers. As a third-party buyer or seller, you don't want to have to look up the contract a patent holder has with an initial seller to make sure you aren't in violation of patent rights. Can you imagine how much research and paperwork you would need to do to have even a single garage sale? To allow patent holders to selectively retain patent rights after the first sale would fundamentally change how commerce works. Now, this is not to say that patent holders can't negotiate licenses or contracts with distributors, but let's read how the courts have dealt with these contracts in the past. This court accordingly has long held that even when a patentee sells an item under an express restriction, the patentee does not retain patent rights in that product. In Boston Store of Chicago versus American Graphophone Company, for example, a manufacturer sold graphophones, one of the earliest devices for recording and reproducing sounds, to retailers under contracts requiring those stores to resell at a specific price. When the manufacturer brought a patent infringement suit against a retailer who sold for less, we concluded that there was no room for controversy about the result. By selling the item, the manufacturer placed it beyond the confines of patent law, and could not, by qualifying restrictions as to its use, keep it under the patent monopoly. 2 decades later, we confronted a similar arrangement in United States versus Univiz Lens Company. There, a company that made eyeglass lenses authorized an agent to sell its products to wholesalers and retailers only if they promised to market the lenses at fixed prices. The government filed an antitrust lawsuit, and the company defended its arrangement on the grounds that it was exercising authority under the Patent Act. We held that the initial sales relinquished the patent monopoly with respect to articles sold, so the stipulation fixing resale prices derived no support from patent and must stand on the same footing as restrictions on unpatented goods. It is true that Boston Store and Univiz involved resale price restrictions that at the time of those decisions violated antitrust laws, but in both cases it was the sale of the items, rather than the illegality of the restrictions, that prevented the patentees from enforcing those resale price agreements through patent infringement suits. And if there were any lingering doubt that patent exhaustion applies when a sale is subject to an express or otherwise lawful restriction, our recent decision in Quanta Computer versus LG Electronics settled the matter. In that case, a technology company with authorization from the patentee sold microprocessors under contracts requiring purchasers to use those processors with other parts that the company manufactured. One buyer disregarded the restriction, and the patentee sued for infringement. Without so much as mentioning the lawfulness of the contract, we held that the patentee could not bring an infringement suit because the authorized sale took its products outside the scope of the patent monopoly. What's important to note in all of these cases is that when a contract was violated, the courts didn't recognize a patent rights violation. As the court is about to explain, as soon as the patented item is sold, the patent rights are extinguished and all that is left are contract rights. Turning to the case at hand, we conclude that this well-settled line of precedent allows for only one answer. Lexmark cannot bring a patent infringement suit against impression products to enforce the single-use, no-resale provision accompanying its return program cartridges. Once sold, the return program cartridges passed outside of the patent monopoly, and whatever rights Lexmark retained are a matter of the contracts with its purchasers, not the patent law. But if things are so simple, then why did the federal court find something different? Why did they decide that the patent rights hadn't been exhausted or extinguished? The federal court reached a different result largely because it got off on the wrong foot. The Exhaustion Doctrine, the court believed, must be understood as an interpretation of the infringement statute, which prohibits anyone from using or selling a patented article without authority from the patentee. Exhaustion reflects a default rule that a patentee's decision to sell an item presumptively grants authority to the purchaser to use and to resell it. But the Federal Circuit explained the patentee does not have to hand over the full bundle of rights every time. If the patentee expressly withholds a stick from the bundle, perhaps by restricting the purchaser's resale rights, the buyer never acquires that withheld authority, and the patentee may continue to enforce its right to exclude that practice under the patent laws. The misstep in this logic is that the Exhaustion Doctrine is not a presumption about the authority that comes along with a sale. It is instead a limit on the scope of the patentee's rights. The right to use, sell, or import an item exists independently of the Patent Act. What a patent adds and grants exclusively to the patentee is a limited right to prevent others from engaging in those practices. Exhaustion extinguishes that exclusionary power. The purchaser exercises no rights created by the Act of Congress, nor does he derive title to the item by virtue of the exclusive privilege granted to the patentee. As a result, the sale transfers the right to use, sell, or import because those are the rights that come along with ownership, and the buyer is free and clear of an infringement lawsuit because there is no exclusionary right left to enforce. So it looks like the federal court saw patent exhaustion as a default in selling an item that could be altered through a clearly communicated contract, and the Supreme Court disagreed. They see patent exhaustion as a right on the buyer's part. When you buy an item, you can be assured that you own it. It is possible to enter into a contract regarding that item, but again, that's a contract issue. Patent rights are no longer in play. But, so far, we have talked only about domestic sales. Remember that the district court denied a motion to dismiss for return toner cartridges purchased abroad and then imported into the U.S. by impression products. The federal court ruled that Lexmark had retained some of their patent rights in foreign sales as well. As we're about to see, the Supreme Court views foreign sales similarly to domestic sales, and, to justify it, it borrows from copyright law. This question about international exhaustion of intellectual property rights has arisen in the context of copyright law. Under the first sale doctrine, which is codified at 17 U.S.C. 109a, when a copyright owner sells a lawfully made copy of its work, it loses the power to restrict the purchaser's freedom to sell or otherwise dispose of that copy. In Kurtzang v. John Wiley & Sons, Inc., we held that this first sale rule applies to copies of a copyrighted work lawfully made and sold abroad. We began with the text of Section 109A, but it was not decisive. The language neither restricts the scope of the first sale doctrine geographically nor clearly embraces international exhaustion. What helped tip the scales for global exhaustion was the fact that the first sale doctrine originated in the common law's refusal to permit restraints on the alienation of chattels. That common law doctrine makes no geographical distinctions. The lack of any textual basis for distinguishing between domestic and international sales meant that a straightforward application of the first sale doctrine required the conclusion that it applies overseas. So we see that the Supreme Court has chosen to parallel patent law with copyright law, which it has done many times before. Applying patent exhaustion to foreign sales is just as straightforward. Patent exhaustion, too, has its roots in the antipathy toward restraints on alienation. And nothing in the text or history of the Patent Act shows that Congress intended to confine that borderless common law principle to domestic sales. In fact, Congress has not altered patent exhaustion at all. It remains an unwritten limit on the scope of the patentee's monopoly. Where a common law principle is well established, courts may take it as given that Congress has legislated with an expectation that the principle will apply, except when a statutory purpose to the contrary is evident. And differentiating the patent exhaustion and copyright for sale doctrines would make little theoretical or practical sense. The two share a strong similarity and identity of purpose, and many everyday products, automobiles, microwaves, calculators, mobile phones, tablets, personal computers, are subject to both patent and copyright protections. There is a historic kinship between patent law and copyright law, and the bond between the two leaves no room for a rift on the question of international exhaustion. Now, Lexmark has argued that patent exhaustion within the United States is possible because the patent holder started out with U.S. patent protections and then was able to negotiate a sale from that position of power. However, international sales are not protected by U.S. patent law, so the patent owner is not able to negotiate sales from that same position of power. A U.S. patent holder can't get the same reward outside of the U.S. as it does in the U.S., so foreign sales shouldn't exhaust patent rights. Lexmark even cited to a particular case, Bosch v. Graf, to support their case. However, the Supreme Court disagreed and pointed out the difference between the cited case and Lexmark's. The territorial limit on patent rights is, however, no basis for distinguishing copyright protections. Those protections do not have any extraterritorial operation either, nor does the territorial limit support the premise of Lexmark's argument. Exhaustion is a separate limit on the patent grant and does not depend on the patentee receiving some undefined premium for selling the right to access the American market. A purchaser buys an item, not patent rights, and exhaustion is triggered by the patentee's decision to give that item up and receive whatever fee it decides is appropriate for the article and the invention which it embodies. The patentee may not be able to command the same amount for its products abroad as it does in the United States. But the Patent Act does not guarantee a particular price, much less the price from selling to American consumers. Instead, the right to exclude just ensures that the patentee receives one reward of whatever amount the patentee deems to be satisfactory compensation for every item that passes outside the scope of the patent monopoly. This court has addressed international patent exhaustion in only one case, Bosch v. Graf, decided 125 years ago. All that case illustrates is that a sale abroad does not exhaust a patentee's rights when the patentee has nothing to do with the transaction. Bosch, from the days before widespread adoption of electrical lighting, involved a retailer who purchased lamp burners from a manufacturer in Germany with plans to sell them in the U.S. The manufacturer had authority to make the burners under German law, but there was a hitch. Two individuals with no ties to the German manufacturer held the American patent rights to that invention. These patentees sued the retailer for infringement when the retailer imported the lamp burners into the United States, and we rejected the argument that the German manufacturer's sale had exhausted the American patentee's rights. The German manufacturer had no permission to sell in the U.S. from the American patentees, and the American patentees had not exhausted their patent rights in the products because they didn't sell the individual items to anyone, so purchasers from the German manufacturer could not be thereby authorized to sell the articles in the United States. Our decision did not, as Lexmark contends, exempt all foreign sales from patent exhaustion. Rather, it reaffirmed the basic premise that only the patentee can decide whether to make a sale that exhausts its patent rights in an item. The American patentees did not do so with respect to the German-made products, so the German sales did not exhaust the American rights. So far, the case looks pretty straightforward. If a patent holder sells a patented item, the item is now part of the free market and the patentee has no more patent rights in the item, but it might still have contract rights. This applies to domestic and foreign sales. But the court is about to address an amicus brief by the government. In this case, there were about 45 amicus briefs that were submitted by different interested parties. Finally, the United States, as an amicus, advocates what it views as a middle ground position, that a foreign sale authorized by the U.S. patentee exhausts U.S. patent rights unless those rights are expressly reserved. Its position is largely based on policy rather than principle. The government thinks that an overseas buyer's legitimate expectation is that a sale conveys all of the seller's interest in a patented article, so the presumption should be that a foreign sale triggers exhaustion. But at the same time, lower courts long ago coalesced around the rule that a patentee's express reservation of U.S. patent rights at the time of a foreign sale will be given effect, so that option should remain open to the patentee. The government has little more than long ago on its side. In the 1890s, two circuit courts, in cases involving the same company, did hold that patentees may use express restrictions to reserve their rights in connection with foreign sales. But no coalescing ever took place. Over the following 100-plus years, only a smattering of lower court decisions mentioned this express reservation rule for foreign sales. And in 2001, the Federal Circuit adopted its blanket rule that foreign sales do not trigger exhaustion, even if the patentee fails to expressly reserve its rights. These sparse and inconsistent decisions provide no basis for any expectation, let alone a settled one, that patentees can reserve patent rights when they sell abroad. The theory behind the government's express reservation rule also wrongly focuses on the likely expectations of the patentee and purchaser during a sale. Exhaustion does not arise because of the party's expectations about how sales transfer patent rights. More is at stake when it comes to patents than simply the dealings between the parties, which can be addressed through contract law. Instead, exhaustion occurs because, in a sale, the patentee elects to give up title to an item in exchange for payment. Allowing patent rights to stick like a remora eel to that item as it flows through the market would violate the principle against restraints on alienation. Exhaustion does not depend on whether the patentee receives a premium for selling in the United States or the type of rights that buyer expects to receive. As a result, restrictions and location are irrelevant. What matters is the patentee's decision to make a sale. The judgment of the United States Court of Appeals for the Federal Circuit is reversed, and the case is remanded for further proceedings consistent with this opinion. It is so ordered. Now, Justice Ruth Bader Ginsburg concurred with the majority for domestic patent exhaustion, but dissented in regards to international sales. She explains, because a sale abroad operates independently of the U.S. patent system, it makes little sense to say that such a sale exhausts an inventor's U.S. patent rights. U.S. patent protection accompanies none of the U.S. patentee's sales abroad. A competitor could sell the same patented product abroad with no U.S. patent law consequence. Accordingly, the foreign sale should not diminish the protections of U.S. law in the United States. Justice Ginsburg also argues that copyrights are not a good model to base patent rights on in regards to international sales because copyright protections are harmonized under the Berne Convention. This means that countries offer largely the same copyright protections, but the same is not true of patent rights. However, hers was the only dissenting opinion on this matter, and the other 7 judges agreed that foreign sales exhaust U.S. patent rights. So there you have it. The Supreme Court ruled that Lexmark couldn't stifle competition in the marketplace through patent rights after they had already sold their toner cartridges. However, the court affirmed that there were still contract rights open to Lexmark. So if Lexmark should have gone the contract rights route the whole time, why didn't they? Well, one reason is that the contract they had was with their customers, and suing customers is not a great way to encourage people to sign up for your return cartridge program. It's just bad marketing to sue thousands of people for breach of contract. Better to go after your competition, not your customers. Second, there are only a handful of remanufacturers out there, so it's easier to sue a dozen companies rather than thousands of individuals. Third, there is little financial benefit to suing all those people individually. It would take thousands of dollars to successfully sue someone for what? A few $100s in damages at most? Yes, they could technically ask for lawyers' fees, but not every customer is going to have the resources to pay that or anything at all. It would be better to go after a large corporation with deep pockets who actually have financial assets to pay out. Besides, if Lexmark can make it expensive enough for remanufacturers, then maybe they will stop selling remanufactured cartridges and Lexmark gets to retain their monopoly. So it's an understandable business decision to sue Impression Products, but what the Supreme Court found is probably the best thing for the marketplace and the average consumer. This ruling encourages competition in the marketplace and gives consumer access to cheaper ink and toner cartridges. But this isn't the first time that Lexmark has been to the Supreme Court to fight cartridge remanufacturers. They have tried this before using the Digital Millennium Copyright Act, or DMCA, and sued a company named Static Control Components for selling microchips to replace the ones in Lexmark cartridges, which restrict the cartridges to one use. Lexmark sued under Section 1201, which makes it illegal to circumvent technological protection measures. But the Sixth Circuit Court of Appeals rightly pointed out that the DMCA was meant to stop pirates, not give companies an easy way to create artificial monopolies. If we were to adopt Lexmark's reading of the statute, manufacturers could potentially create monopolies for replacement parts simply by using similar but more creative lockout codes. Automobile manufacturers, for example, could control the entire market of replacement parts for their vehicles by including lockout chips. Congress did not intend the DMCA to be used offensively in this manner, and maybe that case would have ended there, except Lexmark had sent out a letter to SCC's customers saying that they had broken the law, so SCC countersued under the Lanham Act, which regulates trademark law. They said that Lexmark had made false statements or false advertising about SCC when Lexmark sent out the letters. That case also went to the Supreme Court, who also ruled against Lexmark. Again. So there you have it. Lexmark has tried to use copyright and patent law in order to stop cartridge remanufacturers, and twice has been denied by the Supreme Court. The Supreme Court has pointed out that Lexmark still has contract rights that it can use to try and enforce its return program cartridge policies, but for now, remanufacturers are safe to sell refilled cartridges and let us, as consumers, decide who to buy from. Now, DJ Gilcrease has asked how the Lexmark case affects the Monsanto case. Bowman v. Monsanto was another case involving patent exhaustion that came before the Supreme Court. Monsanto had created genetically modified GMO seeds and required buyers to not collect, use, or sell the seeds from their harvests. Bowman had bought and planted Monsanto GMO soybean seeds second-hand. Monsanto sued him for patent infringement. The Supreme Court unanimously ruled that Bowman's conduct infringed Monsanto's patents, and that the doctrine of patent exhaustion does not permit a farmer to reproduce patented seeds by planting and harvesting saved crop seeds without the patent holder's permission. So it's an exhaustion issue, but not the same. Monsanto's seeds reproduce themselves, where Lexmark's cartridges do not. Monsanto sued the user for a patent violation, where Lexmark sued a competitor. Monsanto sued the end user, who was also the violator. Lexmark sued the competitor, who was not. Lexmark and Monsanto both have a contract/license violation claim against the end user for violations of the license agreement. In Lexmark, the customer was supposed to return the discount cartridges back to Lexmark, but somehow the cartridges still got to Impression Products. In Monsanto, seed buyers were bound not to resell their seed, yet they sold the GMO seed to Bowman. So, Monsanto had a patent claim because its patent rights had not been exhausted or extinguished because it had the right to keep selling new generations or reproductions of its patented seed. Think of the seeds as individual items. You don't have the right to reproduce someone's patented item, even if that item grows into a plant that produces more seeds. But Lexmark does not have a patent claim because its patent rights were exhausted with the selling of its individual cartridge. Since Impression Products is not reproducing a new item but refurbishing an old one, there is complete exhaustion or extinguishment of the patent rights. So that's Lexmark v. Impression Products, brought to you by DJ Gilcrease. Thank you very much for your support, DJ. Also, special thanks to Tactical Bra for all of your writing, editing, and discussion time on this story. I look forward to your comments below. I am Leonard French, your favorite copyright attorney. I'll see you again on Sunday at 10 a.m. on twitch.tv/Leonard French, as well as the next YouTube video. Love you all. And in 2001, the Federal Circuit adopted its blanket rule that foreign sales do not trigger exhaustion, even if the patentee fails to expressly reservate.